A quick question before we start. The roll call, do we have to wait till after you swear in, Mr. Paul, or do
We'll
we?
do the second roll call. Yes, sir.
So we'll do a second roll call after? Is that what you're saying?
Yes.
Okay, all right, okay. So it's 2:31. I'd like to call the Civil Service Commission meeting to order. Ms. Van Blargen, would you take the roll call, please?
Chair Cantrell,
Present?
Commissioner Tilka,
Here.
Judith Ann McLaughlin will be late, and Christina Ponte, she won't be coming back. Her term's ending next month, so she will not be back. So with the new member, we do have a quorum, and I will get started and swear you in. And that is James Paul.
That'll work.
You would raise your right hand and repeat after me. I, James Michael Paul,
I, James Michael Paul,
do solemnly swear
do solemnly swear
that I will support the Constitution
that I will support the Constitution
of the United States,
of the United States,
the Constitution of the State of Florida,
the Constitution of the State of Florida,
the Charter,
the Charter,
and the Code of Ordinances
and the Code of
of
Ordinances
the City of Madeira Beach,
of the City of Madeira Beach,
and that I will faithfully discharge
and that I will faithfully discharge
my duties as a member of the Civil Service Commission
my duties as a member of the Civil Service Commission
for the City of Madeira Beach
for the City of Madeira Beach
to the best of my ability
to the best of my ability
in the manner provided by law.
in a manner provided by law.
Welcome. And I'll do a new roll call. Chair Cantrell,
Present?
Commissioner Tilka, Commissioner Paul,
Present.
we have a quorum.
Okay. All right. Just formality, any public comments? I don't see any public. You guys okay to move on? Okay. All right. Welcome. We're glad to have you here. Yep. So let's move on to the approval of minutes for item A, 2024-0409, Civil Service Commission meeting minutes. Does anyone have any concerns there? Is that okay to approve?
You have a motion?
I'll make a motion, we approve 2024-0409 minutes.
Wait a second.
Second.
Okay.
Commissioner Tilka,
Yes?
Commissioner Paul,
Yes.
Chair Cantrell,
Yes.
the motion carried 3-0.
Okay, next item is approval of minutes for 2024-0521 Civil Service Commission meeting minutes.
I thought that's what we just approved. Did we just approve the minutes?
We only did one. We only did one.
Oh, you
Do we
want to
just
do
do
them
them all?
individual?
Is it okay to say all?
Yes.
So we don't have to do each line item? Okay.
We can redo it for the other two, or you can do them each one if you want to.
You guys,
So I'll make a motion, we approve the 2024-0521 and 2024-0701 minutes.
Second.
Okay. Commissioner Tilka,
Yes?
Commissioner Paul,
Yes.
Chair Cantrell,
yes.
the motion carried 3-0.
Okay, the HR update. Would you like to do that, Ms. Powers? This looked pretty neat. There's a lot there.
There is. All right, so for our open positions, we've got rec ground maintenance, full-time, he's replacing somebody. We've got a recreation leader, one part-time, also a replacement, and a sanitation worker, full-time. This replacement we had on hold for a little bit because we have the side loader, so we wanted to see if we actually needed it, and we do. So we put that back on the board there. I was able to attend the HR State Conference in Orlando a couple weeks ago, which was fabulous. It's a lot of great information, so my head's spinning a little bit still from that. But the main point I felt like from that conference was AI, good and bad. So I'm kind of unpacking what the good is from the vendor side and then what the bad is from the lawyer side. I've already asked Mr. Eschenfelder to create an AI policy, so he's done that. We're going to circulate that around to our department heads, make sure everything's okay, and then I'll present it to you guys. Let's see. I also was able to meet with the Treasure Island HR director, and she, I feel like, is doing a fabulous job there. So I'm going to go shadow her to see what she's doing and what her department is doing to see what we can do better. One thing that she said that I really liked was a once-a-month onboarding, which was really cool. It's more of a nitty-gritty onboarding where we can meet all the directors and go through policies a little bit further, but we would still have the first day new hire onboarding where they do all the training and stuff like that. So it just kind of gets people a little more used to the city and seeing all the directors and stuff like that. So we'll see how that goes. Things that I'm looking at doing, I'm still looking at training. There's a lot of different training options. ICMA has a really good one, but it's very expensive, so I kind of wanted to see different options for that. We do yearly training through Target Solutions, your regular ones like sexual harassment and conflict management, but we're looking to add some more, and I have those listed here. I also, at the conference, spoke with a company called Wild Spark, and they customize a training for you, and it's more like a leadership training, which I thought was pretty cool. They do it's once a month where they do online training, and then they get together as a group to do more brainstorming and how did you actually implement these ideas, or have you had this situation before? So it kind of gets us together and not just sitting at a computer. And that one's not that bad. I think they quoted me $400 to $500 a month. Let's see. I know we have a compensation study update next, so I'll skip that one. Maternity and paternity policy, we did put that in the new handbook, so that is in there for you guys to review. Both Robin and I felt like it was very well written, so thank you, Rob. And then I'm also looking at a couple of applications for motivation and employee communication. There's two companies called Motivosity and Beekeeper. I kind of like it more so for the communications because right now we don't really have anything that push notifications to employees that we're going to be closed for a hurricane like we're expecting now. So hopefully we can set that up pretty soon. And it's not very expensive. I'm just in the beginning stages of that, so I don't have too much information on it. Other things that I'm still looking at researching is the employee satisfaction survey. The HR consortium is actually looking at that, so I'm hopeful that we can kind of come to a compromise there and have just one. Social media policy, I haven't touched that yet, as well as the phone policy. But I have touched the Paycom, and we are now online for personnel discipline forms and evaluation forms, so that's all online. And I'm also going to look into refreshing the application because I don't think we've looked at that in many, many years. Mm-hmm. And I think that's all I have for that.
Thank you, it's a lot, it's a lot. Mr. Gomez, how you doing, sir? The update for Gearing Group, is that going to come, is that information through you, or?
It's in progress right now. We just had we have a meeting with them every other week. Currently, they have all of our job descriptions and our pay plan. They have reached out to all of our comp sets to try to get that information, so we're still in the works on that.
Okay. Had you guys already had the initial meeting with them then?
Yes.
Okay.
Mm-hmm. Not yet. I believe that they're looking at the comp set, and then they're going to ask us questions too to try, because some of the job descriptions and titles don't quite match, so they kind of have to see which ones go together so they can go ahead and talk to the staff members.
Okay. I know one of the things we had asked for as Civil Service Commission is that we were involved with that, like the initial meeting when you originally start talking. And I'm not aware of that happening. So that, and I don't want to get in the way of interviewing employees or anything like that. That's not, we don't need to be involved in that. But is there any meeting where they come in, they sit down, they talk, and they say, hey, this is what we're going to do?
I can have them come talk at our next civil service meeting and give a formal update, but we have just a staff meeting every other week to see
Okay.
the updates and what they're doing.
That won't cost additional money for the city to do
It
that?
shouldn't, but I can let you know if it does.
Okay. Good. Would you guys be okay with that?
Yes.
Yeah. I'd like to hear more about what they're doing, what their intention and progress would be. Okay, anyone else got questions on that? I guess I should be asking you guys if you have questions of these, and I didn't. Sorry about that.
I'm just curious, has that been done before, and this is doing it again, or is this a first time?
This is the first time with this company. The last time it was done was in 2009. I don't remember the name of the company.
I
But
can't
it was
off the
a,
top of my head.
it was a limited study.
It was very limited.
It was a limited study. No, 2019, sorry,
Mm-hmm.
2019. It was a limited study, then we ended up having COVID, and they only made recommendations for a certain subset of employees. And because of COVID, everything shut down, it wasn't implemented. And if you go back and you look at what they set up for the pay scales, it doesn't even match what we're offering right now. So it was necessary to look at it across the board. The other thing is, over the years, and it's no fault of anyone in here, but over the years, you could tell different jobs came up and different people wrote different job descriptions, and there's no uniformity. Not only that, if you go back and you try to apply it towards any type of federal index where you look at the classifications, it's not easy to do. So one of the things we've asked them to do is make it to where it's got the standardized format, so that way if we need to go back and do any type of future analysis, it makes it easier for us to do it, and then we're not going to be spending the money every time we turn around. It gives us a platform to go by to say, okay, this is what's more realistic. So hopefully that's what they're going to tell us they're doing. Okay? Okay. You got anything, Mr. Tilka? All right, Dr. Tilka, sorry about that. Okay. For old business, guys, we're back to the draft of the Madeira Beach Policy 2024 with the edits through July 8th, 2024. So this is going to be on page, it looks like it starts on page 20 of our handout. I've got to plug in my laptop, guys. 1 second. I've got notes on my laptop. So this process started, Mr. Paul, this process started how many years ago, Mr. Eschenfelder? 2021. And it's been through, I guess, many revisions. That's the safe way to say it, right? They started out with an old policy, looking at it. Mr. Eschenfelder, there were some things that happened. Mr. Eschenfelder offered up this policy, basically, that we're looking at right now. There was a hybridized study between the two of them. There was confusion on which route to go, to the best of my knowledge, because it was before me. And it came down to the Civil Service Commission. We said, hey, this policy is better than anything we looked at. And we basically started over looking at Mr. Eschenfelder's policy and asking for recommendations on what's the law say, what is, I mean, the normal things. What's the law say? What do we not need to mess with, and what do we need to look at? Is that a fair assessment? Is there anything you would like to add? Because really, you've been here through the whole thing, and you could probably give more insight.
Well, so when I took over for labor and employment for the city, I read what the personnel policy is. I don't know if you've gotten a copy of the current personnel policy. That's probably something that the clerk could get you, but safe to say, given your professional background, you would not be too very happy with it. It's
I've seen all kinds of.
Yeah, it's not organized very well, and, it could use improvement. So I spoke to the city commission in 2019, and the city commission indicated that it would like a project to be initiated to just give us an all-new personnel policy. There was a different city manager here at the time, I think all different, well, Commissioner Tilcomb might have been here, but otherwise, different cast of characters. And so I presented a version of a local government personnel policy that I've refined over years. And I refined it to sort of this size of an employer and how they operate as best I could. But I think the best way to say it is there was, under the prior city manager, there was some internal resistance to that much change, and I don't understand why our document can't work. And so what I had produced was set aside, and instead we embarked upon a very long process of trying to put the square peg into the round hole with the current document. And then at some point, this cast of characters came in, and under Chair Cantrell's leadership, he's like, look, we've all been frustrated for so many months trying to do this. Let's just go back to, this fresh, clean slate model. So we lost a lot of time, but at the end, I think it's a better, we're going to end up with a better work product to recommend to the commission. So that's sort of the long arc of history of why it's taken us from 2021
This is a
to-
complete overhaul, replacement
Yes,
of the
yes,
existing.
yeah. Yeah, they're under the city rules, personal policies adopted by ordinance, and so there will be an ordinance that adopts this, and it will repeal what's in existence right now.
Okay. You want to add anything, Mr. Tilka?
Good.
Okay, all right. There we go. So let's start with page 20. Let's go to page 20 in our documents. And are you okay if, you tell me what you like. Are you okay if I cover it by section? So we could take it like, when we go to section 1, give everybody a second to say, do you got anything with section 1? Should I break it down to section 1, subsection A?
Well, and it's totally up to you, but I think one thing that we neglected to tell Commissioner Paul is that you're taking your seat right as this project is coming in for a landing. Like literally, we've gone through every chapter, I've made edits, that's what you see, the strike-through underlines from previous feedback from the Civil Service Commission. So today, hopefully, is the sort of final, does anybody have anything? And I don't know if you had an opportunity to review this yet, but,
The red lines are the last final.
the red lines are, from my original draft, moving forward, changes and revisions that this CSC has asked me to do to better tailor it to the city and to their views.
Yep. Okay. So let's move forward then. I personally don't have any concerns about page 20 or 21, 22, 23, 24. Then the general policy statement, which is on 25, 26. Does anyone have concerns there?
Nope, it looks good. When that added language at the bottom of the page, all administrative rules, does that mean any of these policies?
No,
Or
so,
is that
so
separate?
the administrative rule would be something that the manager produces administratively, and it would have to be consistent with these rules, not in conflict with these rules. But an administrative rule, as you know, is something that's more inside baseball. It's not really, worthy of personnel policy. It could be a department-specific
Department
rule,
procedure,
like, call-in procedures for sanitation is going to be different than code enforcement. So sometimes you'll see those adopted administratively. And so this just addresses that the CSC has expressed its desire that it wants to see what the administration does before it becomes in effect. Is that a fair way to say that,
Yeah.
Chair?
It boils down to that there's places in here where it says that the employee must follow the
Unless-
director or whatever rule, those rules that they set up for internal, their own section of the city. But there's nowhere in here for us to look at it, and we have to make a ruling on an appeal grievance. If we have to make a ruling before it goes towards a magistrate, then we need to know what it was said, so that way we understand, okay, did the policy apply to the employee?
Got it.
Dr. Tilka?
I'm fine with it.
Okay, so, section 1, employment, A, non-temporary regular employment. Does anyone have concerns with that? I do have one question on item 10, Mr. Eschenfelder. The last sentence of item 10, Absent city charter or contract terms to the contrary, the city manager, city clerk, and city attorney serve at will and the pleasure of the Board of Commissioners, subject only to the terms of the employment contract to the contrary. This doesn't include city treasurer. Could that be included there? Because that's also one of those positions that falls underneath the Board of Commissioners, and it's not us at all. Charter. But these are also the city manager, the city clerk, the city attorney. Those are all charter officers as
Page
well.
is that?
The treasurer does have a different method of being, the manager recommends the finance director / city treasurer, and then the commission approves the recommendation. See, really the
I understand that.
difference between the others, among the four.
Can you fire the treasurer without the commission's approval?
Don't believe the charter addresses that.
But in the charter, it specifically
Says
states
that-
him as one of the officers, and they have to hire him. We have no,
They
Well, they have to hire
they
him, but that's
approve.
not really the issue when you talk about serving at the will and pleasure. That's more on the goodbye side of things.
Okay.
And I believe that the manager has the ability to dismiss the treasurer and does not have to seek approval of the commission to do that. There's nothing in the charter that says.
How about
that.
if he's contracted it, would they have to end the contract in the public?
Well, the contract, I haven't read it, but the contract likely says, has a termination clause, and the termination clause says, the city may terminate. So then the question is, who in the city has authority? The answer would be the manager. Now, of course, that position is a higher level position, and so the manager likely would inform the commission, I believe that the treasurer is not performing well or has engaged in some form of misconduct, therefore, I intend to terminate his contract with us. And, in the future, it might not be a specific individual, it might be a company, that is dealt with where there are multiple professional financial people, assigned to do the city's
Right.
financial service. I'm simply saying that this language tracks the charter language, that indeed, only the city commission can fire the manager, the clerk, and the attorney, so that's why that language is there. That language doesn't address treasurer as well.
Now, in the city charter, it says that city treasurer serves at the pleasure of the Board of Commissioners.
it is,
No, it
It's
says,
there.
no,
Or
the
finance director or
The
city
city
treasurer.
treasurer under section 5.5 in the charter, there shall be a director of finance who in turn shall also be the city treasurer. The director of finance
Fine.
shall be appointed by the city manager, subject to Board of Commissioners approval.
Yeah, but it's the paragraph before that one, I see.
Section 5.5, city treasurer.
see, I'm allowed to look this
I
up
think it's
online, right?
under the charter.
Yeah, it's in the charter, as I just
Yeah, let me
trying to
read
pull it
stated,
up.
Part 1, Charter, Article 5.
it. Under,
Each of the four, the manager, attorney, finance, and clerk, have different methods of how they are appointed. For example, for the attorney, it says the board shall appoint a city attorney upon such terms and for such compensation as the board shall adopt. The city manager, for example, will be hired by the Board of Commissioners under a written employment contract. So just to give you some examples, each of them are different. I read to you the treasurer.
Attorney, city manager.
So
Right here.
again, I think I defer back to Mr. Eschenfelder, but each one is a little bit different.
yeah,
The only one that specifies how you get rid of one is the manager.
yeah. It says in section 5.1, there shall be appointed a city clerk, city attorney, city manager, and city treasurer who shall serve at the pleasure of the Board of Commissioners, and said officers shall be considered charter officers.
Right, but then that does not detail how, the what, or if you need to make a change or terminate or end the relationship, how that happens. The only one where that is detailed or listed is for the manager.
Yeah, I think he was just asking about the pleasure part in that one sentence.
This,
All right, so I think I'll just add treasurer to it
Yeah.
because,
it appears that it should be there,
yeah.
just based on the way I'm reading it.
And it already says absent city charter or contract terms to the
Correct,
contract,
correct,
so
right.
that would,
Yep.
to the extent that
The
it.
contract is separate, yeah. He's talking about the person in that position versus the contract itself. Yeah. Okay, did you guys have anything there? So I need to get. Add city treasurer, okay. Oh, I'm in the wrong file. Here we go. Would you guys be okay to move on to 1B, employment, temporary employment, item B, page 29? Is that okay?
Yep.
Does anyone have concerns on any items within this section?
Just question on that B, 3B, the recruitment of interns. So is that handled or addressed somewhere else, or a non-issue as far as recruiting?
I don't remember why we decided to strike this, but I know as a group we decided that.
That's, I mean, I don't
I
wanna
think
revisit
it
we
was struck under my memory just because Madeira Beach is somewhat smaller than other local governments, and so they might come about an intern through a non-traditional means. And so, you know, if this provision were there, they would have to engage in bureaucracy that might not be necessary.
Yeah. So, Dr. Tilka? Okay, so page 31, item 1, employment, subset C, joint employment. I don't have any concerns.
Nope.
Dr. Tilka? Okay, page 32, is that right? Let me start on the right page. Yep, page 32, item 1, employment, subset D, employment of relatives, nepotism.
I'm fine with that.
No issues.
Okay, page 33, item 1, employment, subset E, reemployment and disqualification.
No questions?
Okay.
Okay, page 34, item 2, personnel files, subset A, file location and content.
Good.
Okay. Page
Definitely agree not to
Pardon me?
have all, definitely agree not to have separate files floating around
Yeah.
everywhere.
Okay, page 36, item 2, personnel file, subset B, access and retention of official personnel files.
No issue.
Okay. Page 37, item 3, probationary period.
Is 6 months common? Even 6 months seems a little long to me, but I don't know if that's,
Mr. Gomez, I think we relied on you somewhat to help us make the decision for that 6 months.
6 months is pretty common
Yeah.
in government.
Yeah, because I know we felt 12 was too long, but I remember, I believe on this one, we asked Mr. Gomez what would work and be beneficial. Is that correct?
6 months is fine.
Okay,
Yep.
all right.
I'm the evil overlord that recommended 12 months.
Okay.
Well, I mean, because I've worked in bigger governments as well, and, a lot of times it is hard really to gauge someone, should they gain protected civil servant status in only 6 months, but it's ultimately a management judgment, and the manager was comfortable with 6 months, so.
Okay, we ready?
I'm ready.
Yep, okay. On page 38, item 4, pay hours of, pay hours of work and work week. Item A, general policies. I think this is the fastest progress we made in 9 months, Mr. Eschenfelder.
Through it.
I think we're good.
Looks good.
Page 39, item 4, pay hours of the work and work week. Item B, allocation of work hours, work week, and work period.
All covered.
Looks good.
Let's see, page 41, item 4, pay hours of work and work week, section C, pay eligibility. C, pay eligibility. Can I ask a question? Not that I want anything changed, but item 1, all the way down just before you get to subset A, there's that last paragraph. It says overtime shall be documented by the city's time off request. However, if this is not feasible, a schedule of work hours or other form of written documentation shall be available to support the designation of overtime. So now my head's just confused. I understand what it says now. Never mind.
I'm okay.
Yes.
Okay. That takes us through to, because we're still on C, it's pay eligibility, right? That will take us through to page 45. Page 45, which would be pay hours of work and work week. Item D, work time records and emergency conditions.
So the pay for work during declared emergency, so what's different than any other overtime? Or is there, or is that just confirming that it's,
What's different than what?
that from normal overtime pay?
Well, it's not so much different as much as under the rule that exists now, I still think it still exists now. It was felt that it was overly generous. Some governments have gone to giving more money to FLSA exempt staff. And really, as you know, if you're FLSA exempt, you work as many or as less hours as needed to do your duty that pay period. Whereas folks who are overtime eligible, if we make you work 2 additional hours, you get 2 hours of overtime pay. And so this is just, setting forth in the personnel policy how in emergency situations we're handling compensation, which really effectively is to follow the model on the FLSA, which is that if you are overtime exempt, you come in and you do your duty as it's needed. And of course, the manager, with his leadership team, his or her leadership team, if you see that one of your directors or other exempt person came in and spent 55 hours, and, really killed themselves helping out with the hurricane, you make that up down the road by letting that person, hey, take the day off or whatever, take a couple days off, and they're salaried, so they still get their full salary. So that's,
This was really meant to address salaried exempt employees.
it was meant to rein back in what has been felt to be overly generous. And in some emergencies in past recent years, the city has sort of gasped at how
COVID.
expensive it has been when everybody who's exempt starts putting in for hurricane pay. So that's why it's
Mostly
spelled
came
out.
about with COVID, because how long we were out of the office, or people who were actually in the office working, we all got time and a half. So I think that was not really written for a COVID policy. It was more for emergency management. So yeah, that's why this is in there.
Got it. Yeah, but then it talks about non-exempt, and it says, shall receive overtime for work in excess of 40 hours, regardless of what non-emergency hours they've worked. I guess, is that confusing?
No,
What we're
because,
saying is it doesn't matter what type of hours, but they still got to meet 40 hours.
well, because
before
that's
they-
also another part of over generous is that some public employers have said, well, if you work during a declared emergency, you get double time.
Well,
or,
okay, that's what I
so
was.
what this is if you're overtime eligible, regardless of why you're working the extra hours, it's 1.5 times. It's time and a half. Period, end of story. During a declared emergency, not during a declared emergency, if you work overtime.
No premium pay for either category, basically.
No.
Got it. So, looks good then, through the end of that
Okay.
policy.
Okay, page 47, item 4, pay hours of work and work week. Item E, salary basis compensation questions.
Looks good.
Okay.
Good.
Page 48, item 4, pay hours of work and work week. Section F, forms.
Good.
Good.
Okay, page 49, item 5, classification and pay plan. Section A, general policies.
Looks good. Was there a previous history of doing it on an annual basis?
I don't know
Now
that.
that's removed, that language that's removed.
I don't know the answer to that. I don't know.
I was just curious if,
As far as I know, we've always done it on the anniversary date.
oh, okay, so that was just
This is, I know this was.
correcting it to match.
This was a
what-
general document, so it was, yeah,
Got
okay.
Good.
Good? Okay, page 50, section 5, classification of pay plan, item B, administration. Am I in the right spot? There we go.
Okay. We're good.
Okay, all right. It's interesting, I don't, for whatever reason, I don't have that sub-item 3 on my electronic document. I don't know why. I'm sure it's just an error. Okay, so page 51, item 5, classification pay plan, subsection C, application.
Oh. You said item 5?
It's classification pay plan, so it's page 51.
Oh, okay, 51.
Page 51, item 5.
Oh, got it, okay.
It goes for a while.
I'm okay with that.
Should we say that employees are encouraged to apply for promotions that they're qualified for?
Under what?
Is that, so at the bottom of page 51, it says we're encouraging employees to apply. Should we caveat it? Is that, if that's potential concern, maybe it's not, but that we're encouraging.
I wouldn't recommend that language simply because you may be accused by a plaintiff attorney of saying, well, you're trying to discourage employees, and what does qualified mean? And,
I get
you know, could work experience. So just, if you think you're qualified based upon the written job description, we encourage you to apply. If the hiring authority, be it a department head or the manager, feels you're not qualified, or that there's someone more qualified than you, because that's the standard we use, is we hire the most qualified candidate for our jobs, then we'll let you know.
Sure, yeah, on the flip side, the argument could be made that if we're encouraging somebody, that's implicitly saying that they're qualified, but I get it. I'm fine with, as long as it's not an issue or a problem that people are
Currently, no.
applying left and right for things they shouldn't be.
I'm okay.
I'm good.
And I think just a final thought on that, you know, that the city does encourage continuing education and so forth. And so if an employee is that close to being qualified and really wants that job, and they've been here 15 years, and management says, you know, we've been looking for you to step up, however, you need this certification, so here's the deal. We'll give you the job, but you got to get that certification in 6 months. If you put in there, they got to be qualified from day one, it kind of prevents that.
And in that event, we also do an offer letter that stipulates they have to do
Finish
those-
whatever
yes,
the condition is.
correct.
No, I'm good. I just, from experience, I know some places have a kind of a free-for-all and people are applying left and right.
Yes, that
Jobs that fit it.
doesn't seem to be the case here, so.
I'm good.
Good, okay. All right, page 56. So it'd be section 6, holidays, item A, administration. We added in Juneteenth to this to match federal. Is that correct, Mr. Gomez?
Yes.
And the 2 personal holidays, correct? That was changed, was it 1 at one time?
I believe they've been 2 for several years.
Okay.
We think we were also looking to add,
So the 2 got added. I had
President's Day.
left no number on there simply because year over year, governing board may decide to raise or lower that personal holiday. But I think the CSE felt that they wanted it to be in the personnel policy has set forth it too. My advice is that might not be such a good idea if in the future we want to pull back to one, then we have to do a whole new ordinance to change the policy, but that was the decision you all made to bake it in, and so that's why it's there.
But then below that, it says the number of which is set by the board. So,
Right, but once you put the two in there, if, it is set by the board when they adopt this, but they can't change it unless they do a new ordinance to change it.
Didn't we have another day when Juneteenth was added?
The President's Day,
Oh, the President's Day, okay.
because that currently is not a holiday for here in, for city employees.
Okay.
I guess we could take off the parentheses around the S and holidays, right? If we're saying it's 2,
Yep,
just to not cause confusion.
understood.
See, we had New Year's Eve, but we got Juneteenth Day on that place. I'm glad.
I'm good.
I'm good.
Sure, I'm not skipping anything. We did, I guess I did A and B together. Are you guys okay with that? I did add A and B together on that. So we'll be going on to item 7 if you guys are okay. Because we talked about the holidays and the administration both.
Yep.
Okay. So we're going to do section 7, leaves of absence. Item, it would be subsection A, vacation leave, maternity, paternity leave. This, in the past, employees were allowed to accrue their PTO for PTO and sick time both. Is that correct, Mr. Gomez? Yes. And it was no cap on the amount of hours that they could have, and if they left the city under a good circumstance, then they were allowed to cash in their PTO.
They're unlimited, whatever the
Yeah.
amount was.
And we, as a commission, agreed that that doesn't make sense. We don't want to limit them. We want to make sure, well, we are going to limit them. We want to make sure that they have time, but
To use.
we agreed that if it's over twice their annual amount, then they either use it or lose it. Is that correct?
Or do they stop accruing? They don't lose it, they just stop
Accruing. Stop
Just
accruing.
caps it.
Yes, they stop accruing. And then sick time, we did some other stuff too but that's going to be a different spot on this. So that's why there's a lot of red line in this area.
Right.
That's why there's a lot of red line. And
And maternity, paternity is separate or in addition to?
it was not here. It was not here. We requested that to be added.
But is that a
You did good job
separate-
on that.
Benefit over and above?
Yeah, it's
Very
on
good
page
job.
61, so the chair will get there.
Okay.
Yep. Since it's all part of it.
Yeah.
Want to make sure I'm not skipping anything here. Page 61 on the maternity paternity, it's item 10 underneath that. I do have a question on this one, and I just want it clarified for me, because I know that if you have a child, there is absolutely no way to put that child into public care until they're 6 weeks old. And when I read this, it says maternity leave is 120 hours, so basically 4 weeks, right? Is that correct? 4 weeks. Shouldn't it be more than 120 hours? 4 times 40 is 160. Is that correct?
Well, it's all a matter of, first of all, this is what was discussed, but it's all a matter of how generous the employer is going to be. This is added time. In other words, you are not required to take from your other leave banks. This is brand-new additional leave. And so if you want more than 120 hours, then you're going to have to go to vacation time,
120 hours is 3 weeks.
right?
It says 4 weeks, so it should be 160 hours.
Yes.
That is correct, right? Does that make sense, everybody?
And is this meant for birth mothers? Do we need to say, I don't want to open up a whole can of worms. This is a big developing issue on
How do you deal with
how.
adopted children?
Just
Yeah.
men, women. If those 4 weeks is meant to be because of the birth,
Well, sub 2 is for
that's the,
parents. So,
Addresses that.
so that's someone who is a spouse
Or adoption.
who is not a mother who gives birth.
So the mother is allowed 4 weeks. This is what I was getting. I just realized the 120 versus 160. Honestly, that was, because they need 6 weeks. If you're a single mother and you need 6 weeks before you can even put your child into daycare, and hopefully there's a spot available to put your child into daycare, that's 4 weeks. Are they also allowed to take the 2 weeks in conjunction with it? So they have that 6 weeks, which provides them the time to get the child care they need. 'Cause
That was my understanding, yes.
that's, I just want to make sure that's, but then if we do that, if the father also works for the city, we talked about the not taking it at the same time because it could put a burden on the city. But does the mother get 2 weeks and the father get 2 weeks both?
From how I'm reading this, it looks like maternity is 4 weeks and then paternity would be 2 weeks, so the father would get 2 weeks.
But it says paid maternity / paternity leave for the parent.
The mother could get both, 4, then plus the 2 if the husband doesn't work here. But if both the husband and wife work here, they can, from what I'm reading, if I'm understanding this correctly.
correct.
The wife can, or the mother can do the 4 weeks and then the husband can do the 2, or the mother can do all 6.
Okay, does it provide, but the way this reads, it doesn't say that it says maternity or paternity, it says maternity, paternity, so can they take it concurrently? Do we want them taking it concurrently? I don't know the answer to that.
Well, there's nothing in this that prevents that, so.
Correct.
I think it's a situation where, and correct me if I'm wrong, Ms. Powers, but the city's arc of history isn't such that we have a boom of fertility, occurring where we're with married spouses that both work here, so I don't think it would be an issue, but.
I do not believe so. It would be very slim if it would be.
All right. Okay,
so the sub 1, the 4 weeks is meant to recuperate from the birth.
Correct.
I'm just making sure I understand, and the 2 weeks is for bonding.
Correct.
Or other logistical things that.
Yeah, or the whole thing, yeah.
Now, for the minutes, are we changing the 120 to 160, or?
Yes,
we're leaving
ma'am.
it? Okay.
yep. But this does make the mother eligible for 6 weeks, which is what's important.
Correct. Yes.
Okay. And then we're not addressing,
Well, I'm sorry,
Yeah.
a birth mother could be 6 weeks.
Birth mother.
But not the, I mean,
not
do
the
we-
adopted mother.
Well, I mean, it just says, in the first part, it just says mothers. It doesn't, if the purpose of it is to recuperate from giving birth, then I think we should put in there birth mothers or make that clear. And then the 2 weeks is for is for administrative, personal, bonding, whatever needs to be done, if that's what the
So
intent.
I'll add the word birth in front of the word mothers.
I think that's fair.
And can I ask this, and I hope nobody ever experiences it, does that also apply to a mother who has a demise? So if the baby passes, is the mother also provided that time because they are a birth mother at that point?
I would think so, yeah, because they're recuperating from the actual birth.
Yeah.
Good, okay, I think that's important. That's, all right. Anyone else got questions?
Looks good.
Nope, that's good. Okay, that puts us to page 62. Let's see, so we're on section 7, leaves of absence, item B, sick leave. B, sick leave.
So part-time and temporary employees are not eligible for paid sick leave. Before that, it says 96 hours per year, prorated if the employee works less. So are there situations where an employee's working less, but they're still eligible? Because, you see what I'm saying? So this says full-time,
What's your trigger for part-time?
Under 30 hours.
Yeah, so I think you could have a full-time employee that works 35 hours a week or whatever, and that's what this is attempted to.
got it. So- And it's clear when they're onboarded, what their full-time, part-time, whatever their classification is.
Yeah. And I'm also going to be starting to attach their job description to their offer letter as well, so we know exactly what they're being hired for.
So this, it's not capped, the sick leave? If I'm looking at subparagraph 4.
Did we, Mr. Gomez, did we decide, I'm trying, something in my head tells me we decided to cap, or was it just not pay out sick leave?
Under sick leave
Yes.
on page
Item-
62, 63,
Page 62, number 4.
full-time employees. I'm not even sure why it's saying sick leave credits.
Yeah.
Full-time employees who fill.
Because when we get over to payment of unused sick leave, which is on page
Well,
65,
it's under FML. Leave?
it's, if you look at A, as of the effective date of this policy, unused sick leave credits shall expire upon employee separation from the city employment. We don't want people to get, if they're sick, they
not a
need to
retirement
use their.
plan.
Yeah, if they're sick, they need to use their sick time. You know.
Okay, no, I
And
just
they
wanted to
can-
make sure that
and they
there was
can-
no cap or max.
And they can contribute to a bank, which entitles them the ability to get time when they need time.
Yes,
as well.
PTO donation.
Yep.
Mhm.
So we do have listed as unlimited, and it's 96 hours, is that what it read, 96?
That sounds right.
So it's 12 hours, 12 days a year sick leave?
Yes.
Okay.
So right now, because it says as of the effective date, so right now, if someone leaves, they do get a payout?
They get 25% of their sick pay.
Yeah. Which they won't get, if I remember correctly, they won't get sick pay payout. We are changing, even though we're changing the pay for PTO, their paid time off, they're allowed to do a one-time cash out by June of 2025,
January 1st of 2025.
January 21st of 2025, for what's currently accrued. So that way, up to like that, whatever that double their time is, they can get that paid out because they counted on it. That was part of what they're currently receiving. but after that date, it's no longer, they're no
They
longer
either
eligible.
use it or take the payout.
Yep, yep.
And I believe the other thing that we were taking out is if you don't take a sick day, you get a payout as well. And we're taking that out because we think people should use their sick time.
Say that one more time.
Currently, if you don't use any sick time, you get a payout during the year.
Currently.
Currently.
That's going away.
Correct.
Without any compensation for it.
Correct.
Yeah.
Then have a mental day.
A mental day. And you're right, it is a retirement plan. I know the way that Mr. Gomez also explained it to us, that the employees that receive overtime tendency there is that they have to use theirs because they don't get paid if they don't work. Where if there's
Salaried, they just don't
salaried,
put
they
in
don't
for it.
have to, and they're usually the ones that cash out on it. Is that correct, Mr. Gomez?
It was our higher level employees that were not recording sick time. And therefore, they were the ones receiving, if you're referring to the sick leave incentive,
Yes.
Sir?
when you do not take it, yeah, it's mostly employees who, salaried employees where you don't record but less than a day that you're out.
Like me, I
Just
work
sick
8
leave
hours.
incentives are old and really they're kind of like compensatory time off. They're really not needed. They're just more work that's not necessary in 2024, really.
Yeah, true.
Did we discuss that there's like a minimum amount of hours they have to contribute to the sick leave bank to be eligible to participate in the sick leave bank? Because it doesn't make any sense for somebody to put 1 hour in and say, oh, I get to
No.
contribute.
I don't think we discussed this, no.
Is it appropriate to,
Well, when we were discussing the concept of a sick leave bank, I do believe that I put that out there, that there could be inequities where people contribute hardly nothing, but then end up getting a lot. And after much discussion, the decision, at least at that point, was to not really address that. And so if you do try to create some minimum, participation thing, how do you peg what that is? How do you set that? People have different personal circumstances, that where they could contribute more or not contribute more.
I mean, it's usually going to be the ones with significant hardships that need it, and so they're not going to be in a position usually to donate, if that's the intent. So I would say usually that's not a criteria for it.
okay,
Someone who's healthy and doesn't ever use theirs and wants to donate, donates, and then the ones that have significant issues are the ones that wind up using it. I mean,
And I think, with sick leave banks, I'm, you didn't hear the speech, but I'm generally not a fan of them. But I want to make sure that they are really not governmental programs, so I put in here, basically, look, the manager can help put the framework here for you all to donate to, but this is up to you all as employees. And if some of you wish to be generous and donate to the sick leave bank, you may do so. If some of you need to access it because you burned through your vacation, you may do so. If the bank empties out and there's nothing left, then the bank empties out. It's really not a city concern. This is employees being generous to employees. And, there are even circumstances where there isn't a lot in the bank, but then employee, a beloved employee gets cancer or something,
yeah, I was
and
just gonna use
everybody
that
donates at that time,
example, but-
so I think that organic way of it flowing is the best way to have it go.
understood, okay, all right.
And I do feel like with this maternity policy, a lot of that would go away as well, because I know a couple times we've used it for maternity leave.
Yeah,
That's nice. Yeah.
yeah. Okay.
I'm
Questions?
good.
Okay, so it's item 7, leave of absences, C, section C, personal medical appointment leave. I don't have any questions. Does anyone else? Okay. Page 68, item 7, leaves of absence, section D, bereavement leave.
I'm fine, I'm just curious, how many, do we have collective bargaining agreements and how many?
The fire department.
Fire department.
Any questions?
I'm good.
Good. Okay. Page 69, item 7, leaves of absence, section E, military leave.
Looks good. I see no red, so I'm assuming it's been debated
Yeah.
sufficiently.
Yeah. Page 71, believe me, there's a lot of debate.
Sorry.
Page 71, section 7, leaves of absences, item F, jury leave. This was interesting. It was one of those things where we came up and, I think it was you, Ms. Powers, that said that, we're a city and we need to support anybody that has to be on jury leave.
I'd agree, yeah.
That's, yeah. Questions?
Clara actually made a good point about the bereavement. Currently, we have for out-of-state deaths 5 days. So I don't know if we want to,
That
Put
is
that in
there. It says, for up to 3 days scheduled work days, 5 days for employees working 10, oh, I thought that was that way. That's, I thought we had discussed that too.
Yeah, it was 3 days
Yeah.
for, that's local, and 5 days out of state is how I recall it being changed too.
I still think we probably need the 10-hour shift because I know a couple of departments have, they work 4 10-hour days.
I think that should be a different paragraph or something. Got messed up somehow. Should be.
So right now, there is no language to out-of-state that needs to be added.
That,
Yeah, our current one is 3 days local, 5 days out.
I
and
thought we had discussed that in the.
We did. It
We
got
did
changed.
discuss
We,
that.
we did.
Yeah.
It was not supported by the Civil Service Commission. I mean, I think, you
No,
know,
it was.
everybody is sympathetic if a relative is out of state and dies, but you can get anywhere in the United States of America on an airplane in a day. So, you know, there should be drawing a line somewhere. And what does out of state mean? Does out of state mean Georgia versus
Some days
California?
employees working 10 hours.
So it's up to you however many days you want to recommend.
I think it just reads strange. It says 3 days scheduled work days, 5 days for, the ones working 10 hours gets 5 days. Is that how I'm seeing that?
That's 50 hours versus 3 days
Something don't
scheduled
make
work is
sense in that
24.
paragraph.
Yeah, I'm not
Work
sure there's
10
a
hours a
logic to
day, then
5
get
days for
5
those
days.
working
Not either.
4 10s, but.
It just don't read right or something.
What is it currently?
What are we trying to do? I guess that's what we need to get to. Because we can sit there and debate what it's reading.
Well, it's just saying,
But it's, what do we need it to
I
read?
think I was asking if we wanted to mirror what we currently have, 3 days in-state, 5 days out-of-state.
'cause it's now saying 5 days for people who work 10-hour shifts.
But that's 50 hours off if it's
Yeah, so
5
that
days,
don't
or
make
if
no
it's
sense.
3 regular work days, it's 24.
it's
So you're
just
giving somebody working a 10-hour
messed
shift
it
twice
up.
the amount of time. I think realistically, personally, if it currently reads, and you guys would have to agree, if it currently reads it's 3 days in-state, 5 days out-of-state, even if it's just Georgia, it's out-of-state. It's,
That's what the existing policy
that's
is.
existing policy, and
Travel.
I think it would be good to complement that, just mirror it.
I would agree, and to be honest, the 4 years that I've sat at the city manager's office, we haven't had to use that, so I don't think it's
And
a
is there a
common.
distinction currently between 4 10-hour shifts or regular shifts?
No. I don't believe anywhere in our handbook it stipulates the 4-day shifts currently.
No, that should be a different paragraph.
I've read that. I don't remember seeing that in the
I
current
don't
one.
think there is.
Okay, so change to 3 days, 5 days out of state?
3 days in-state, 5 days out-of-state, yes.
Okey-doke.
Are you in agreement? We're all in agreement?
Well, just be clear on what, and I don't care, let's be clear on what is out of state. Is out of state the memorial service, is out of state where the
The
relative
memorial service where you're
lived?
traveling.
Because those might not be.
Yeah.
It could be 5, and we could be dealing with several states depending on how we define it, so that's, just be clear.
Where does,
See what I'm saying?
where does that person died, where they live? That would make sense to
You could die in one place, but being buried over in
Right, right, that's what I'm saying.
could be poured over there.
So I think in that situation, we would make them choose. If they want to go help out family members during that time, and then use PTO for the funeral if it's still over state
Sure.
lines, or,
But that's what I'm saying,
Yeah.
we could define it as the deceased family member either lived or, where they're buried or where the memorial is. If it's out of state, you get 5 days. Obviously, people can supplement or take more time off through other
I'd agree with that.
policies.
So what does that wording need to be? I'm trying to
Yeah,
listen to
yeah,
you.
well, no, I just, when you said out of state, in my mind, I'm like, well, what does that mean? Because what is out of state? But I think if we say where the deceased member lived, family member lived, or where the memorial service or the burial takes place, that triggers the out of state, the 5 days for out of state. Does that make sense?
Mr.
I think it
Archibald?
makes sense.
Yep, I wrote it down.
All right, okay.
If he died in state, but buried
Well,
out
well,
of state,
that's-
he gets 5 days.
Yeah, well, that's
That
one of the
makes sense.
scenarios, if we define it as out of state, where they're buried or where the memorial is, then that would trigger the 5 days.
Okay.
Yeah.
I'm not advocating a position one way or another, I'm just saying let's define it so that it's clear what.
Makes
Out of
sense.
As long as you don't die intestate.
So for the minutes, it would be 3 days in-state and 5 days depending on the location of the burial.
It's either if the deceased lived out of state or if the services are to occur out of state.
Okay.
Okay,
I would be, I would be in favor of that.
all right.
Lived out of state.
We've covered, okay, we were on jury leave, is that correct?
I think you got past jury leave, you're on.
To the witness leave?
72. Yeah.
Okay, all right, so let's move forward to Section 7, leaves of absence, item G, witness leave, which is on page 72. I have nothing.
Is there a limit on, is it capped or limited or no? In a year?
Not that I'm aware of.
It should never occur, but it's, I've had it happen before where someone winds up being a witness numerous times in a year for whatever reason. But I'm fine if everybody should never.
So this is a witness for Madeira Beach. What if they're a witness for someone else?
They're a witness
Well,
for
that-
someone else that's not Madeira Beach's business, correct?
Yeah, that's covered under number 2. I mean, if you choose to be a witness for someone else, then you're a witness for someone else. I mean, you got to take leave if you're going to miss work for that.
Oh, okay. So, yeah, we don't, if it's strictly for city business, then we don't need a cap anyway.
Right. The point here is that if I'm in the middle of doing my job, and because I'm in the middle of doing my job,
I
all
get
of a
to
sudden I
post.
become a witness, or if the city attorney makes me a witness or whatever, because it's a discrimination lawsuit, and he's going to call me and wants me on standby, then I get to be paid for that. You know, I mean, that's only makes sense. Why should I have to pay vacation?
Yep.
But if you're going to be an adverse witness to us, take vacation.
Take a vacation, yep.
Unfortunately,
Or a witness
this
for
does
a
happen
family
from time to
member
time.
or somebody else.
Going off and doing something that's doesn't benefit the city
get
in
it.
any way.
I'm good.
Mr. Tilka?
I'm fine.
Okay. Item 7, leaves of absence, subset H, disability leave, page 73. I believe in these with FMLA. We adhered a lot of your guidance on that, Mr. Eschenfelder, because of the way the law is written. Is that correct?
Yeah, well, this doesn't pick up on FMLA yet. This is disability leave, and so basically it covers worker compensation, and then it covers that if you're released to light duty, then at the direction of the department director, you could be assigned to perform other than your regular duties so that we could at least get some work out of you. But I think the key to subsection H1 is really F, that indicates that you're not guaranteed light duty, because a lot of people feel that if I'm put on light duty, that I get to come and wave that note to my employer, and my employer has to stick me somewhere so that I don't have to use my sick leave. And that, in my experience, people have manipulated that. And so F provides that if we don't have bona fide, leave for you, light duty leave for you, then you're going to have to recuperate at home and use whatever available leave resources are available to you. But, the story that I always tell that just blows my mind is one day I get a phone call from the animal services director saying, well, so-and-so, I have to put her on light duty answering the phones at animal service, even though she's a animal service officer who's supposed to be out picking up dogs. And I said, well, where is the person who normally answers the phone? Oh, she's sitting right next to her. And so they just, stuck because they felt they had an obligation to, and you don't. I mean, the city does not have to pay you to come and displace someone out of another job that person's otherwise working. But if we do have bona fide light duty work, like sometimes the file room has not been rearranged in 3 years, so because you can't be out doing your regular duty, please go in the file room and, take a week, rearranging it.
Does this account for or provide enough discretion to end? So let's say it's given, but then it goes on too long or circumstances change. I don't know if it says we can terminate it.
Well, yeah, so you got to read the whole thing. It's quite long. But yes, at the end, if you are unable to perform your essential functions and there are no other opportunities for you, then the end is that you can be separated.
It's, when you get under E, it's the sub 1, 2, 3, 4, 5. They can be voluntarily resigned or non-disciplinary separated. Is that correct?
Correct. Yeah, and this policy sets up what I call an alternative employment program where, the city can have a last-ditch effort, to try to help you find some other open position in the city that you might be qualified for. But, if those efforts don't work, at the end of the day, we have to have someone to be able to fill that position and to perform those duties with or without accommodation. And if you can't do that, then it's time to move on.
Okay, I'm okay.
I'm good with it.
Okay. Dr. Tilka said he was good. So page 76, section 7, leaves of absence. Item I, domestic violence leave.
Good. That's pretty much required anyway.
Dr.
Yeah,
Tilka?
it's a statute.
Okay. Page 77, item 7, section 7, leaves of absence. Item J, leaves of absence without pay.
I'm good. It says they may be approved up to a maximum of 3 months. Is that per year?
Well, that really, if you're at that stage, that contemplates something is really going on and
It wouldn't be
it's
approved
either a
again.
major illness that you're going to recuperate from. And so because, like, one example that I have from my career is there was a fella in the building department. He'd been with the building department for 20-some years, stellar employee, bad medical situation, and the county just made the decision, we're going to let you be here even though you utterly cannot perform and you've burned through your leave, because we are hoping that you're able to come back. He ended up passing away, but, that was a financial decision that the county made in that instance. And, they kept paying his benefits and stuff because it was a sympathetic case, so.
I'm good. Do we know what our health plan says as far as how long someone can, does it match? We
I'd
should
have
check
to look that.
We should check that, because the plan language sometimes contradicts what we're saying in here, and we gotta make sure it matches.
That's 3 months, right?
But I'm fine with it, subject to that.
Dr. Tilka?
I'm good.
Okay. All right, page 76, section 7, leaves of absence. Item I, did I already do this? Domestic violence leave?
Yep.
I did, I'm missing
You're
out.
on page 78.
78, wrong page, sorry, guys.
Yep.
And
All right,
really.
Page
Go
78,
backwards.
here we go.
And really,
Section-
78 through 87 is all FMLA, so it's largely just,
MV.
that's all driven by the federal regs
All
and definitions,
boilerplate.
so you can go through it, but
Would you like to look through it? Okay.
If it matches what's required
It
and
ma- it
has all the
matches.
contingencies, then I'm good.
yeah, it matches.
I trust.
So we're going to judicial leaves, page 88, is that correct?
Yeah, that's the next one.
Okay. Page 88, judicial leaves, it would be section 7, leaves of absence, L, judicial leaves.
Very standard.
Yep, I'm good with that.
Yeah, I'm okay with that.
Okay. All right, next one's going to be really easy. Page 89, Section 8, absence without authority.
Well, you would think it could be simple, but
Okay.
sometimes it's not, no.
I know, as lawyers, I'm sure you
It's-
guys see
it's
stuff
simple on
that you,
paper, but
I'm sure you've seen
there's
things
always
get
a dispute
chewed
on
up,
whether
yeah.
someone has gotten approval or not. But no, I'm fine with it.
Dr. Tilka?
I'm good.
Okay, I'm trying to get my notes caught up. Okay, so page 90. Guys, by the way, we are officially past halfway point. We were 10 pages ago.
Time or in pages?
In pages. Yeah. In time, I don't know. All right, Section 9, non-disciplinary separation from city employment. Section A, resignation.
I'm good.
Dr. Tilka?
I'm good.
Okay, page 91, Section 9, non-disciplinary separations from employment. Item B, retirement.
I'm good?
Page 92, Section 9, non-disciplinary separations from county employment. Item C, death.
Good?
Okay, page 93, Section 9, non-disciplinary separations from county employment. Item D, layoff. This goes on.
Under the heading county employment, is that proper?
Oh, I didn't even realize it read county employment. So for,
I'll fix that.
yeah, okay, good catch, Dr. Tilka. It's weird because on page 90 it reads city. We are on death, or are we on layoff, guys? We're on layoff. All right.
Yeah.
Okay. Good?
So subsection 9, there's a 12-month period of preferential interviewing. I'm assuming we retain full discretion to select for that position, even if someone had, it might be confusing to say preferential interviewing. I'm not sure. You see what I'm saying?
Sorry, I lost where you were.
Oh, yeah, no,
Page
so.
94,
Thank you.
item 9.
So there's not a preference for rehiring, just a preference for interviewing, but I'm not sure what preference in interviewing means, but
What preference in interviewing means is that if
They
you
automatic.
are, if there are two candidates that are for all intents and purposes equal, the tie gets broken if you were someone who was laid off.
for actual hiring though?
Gotcha.
Or just,
For if they've been laid off and they come back and they apply for a job, then under 9, they get preference in interviewing for any job for which they are minimally qualified.
Well, that's what I'm saying, but does that mean that they automatically get it, all things being equal?
All things being equal, they automatically get it. So maybe we want to say,
And receive
interviewing for
preference,
and receipt of.
because interviewing to me doesn't equate with actually.
No, I understand. Yeah.
Getting the
So then I
offers.
would say, so we're adding the word receipt of after the word for.
Adding what,
It
sir?
would be interviewing for or receipt of any job for which they are minimally qualified.
Also, the
Okay.
header on this, several others are state counties.
Yeah, there's a lot of counties needing to
Yeah,
change to
we'll
city.
just do a word,
Yeah,
find
yeah,
and
that-
replace.
it's all the same
Yeah.
header that just didn't
Yeah,
get.
once you change it once,
Yeah,
it should fix
right.
it.
Okay, I got it.
I'm good with the layout.
Okay, page 96, item, section 9, non-disciplinary separations from city employment, I guess. And it's item E, disability separation, reasonable accommodation.
Which number?
This is on page 96, item E, disability separation, reasonable accommodation under section 9.
Okay.
Is that okay? All right. Trying to find my page. Disability separation, no notes.
I'm good with it.
Good, okay. Item, it's page 97, item 9, non-disciplinary separation from city employment. Item F, alternate employment program. Okay.
I'm good.
Okay, so we are now on page 98, section 10, Code of Ethics for Officers and Employees. We actually might make it through this.
We're trying.
You sound surprised. I'm good.
Okay. Okay. Page 100, item 11, discipline and discharge, section A, general provisions.
Good.
Okay. Page 101, section 11, discipline and discharge. Item B, grounds for discipline or discharge. think Mr. Eschenfelder made a really exhaustive list, which is awesome. Problem is it may not be exhaustive enough,
Well,
is that right?
You're gonna find an employee's gonna find something that's not listed,
Yeah.
guaranteed.
Well, that's something almost always is conduct unbecoming, so that's in there.
So the or for any other just cause phrase at the very beginning before we get to number one, that's the catch-all. I'm fine with that.
Dr. Tilka?
Yeah, I'm good.
Okay.
Just a brief discussion on 14.
14?
As far as language, I mean, just a brief discussion, it's language. Everybody's uses it differently, and I think that, we've got certain protections in using certain words. It seems like we're more liberal than ever, but is there any ideas there?
I don't know. Any thoughts? Because I look at this and I'm not reading it, I think, the same way Dr. Tilka is reading it.
So I guess, yeah, can you say it again? I mean, that's dangerous, it's dangerous and amorphous, and what about people talking politics or religion at work, because that could offend somebody, but, so, it's problematic just because it's so vague, but I'm fine with it, I think. What was your,
No, I just wondered how you got,
Well,
others felt.
We're not allowed to do politics here today.
No, I'm not saying
Well,
politics, I'm just saying.
Send emails
usage
on
of
somebody doing
words.
politics. or
See,
nothing.
one of the things where I think is that if you're saying something in general conversation, another person takes offense to it as an insult,
Yes.
that person owes it to the first person, hey, that doesn't work for me. And beyond that point, it's insulting and abusive. But that first, I mean, if you're just having a conversation,
I'd agree with
you
that.
don't always know, that, hey, what I might say in my day-to-day conversation is not what you would say. But once they're identified, then it's,
You say, well, you're a dummy. I mean, where do you go from there? Is that?
I don't know, it makes me feel like my parents talking to me when I was 5 years old, you know? There we go. Like,
I mean, could it be taken as, abusive?
I mean, you could, again, this,
You can apply almost any rule in a outrageous way,
Right.
You can pick any of these rules and come up with a scenario where it would be ridiculous. And that's why you have management team who makes reasoned applications of these rules. That's where you have a city attorney who says, I don't think in this particular case you should do that because you may create a First Amendment issue. But I have, worked with this set of rules, including 14, for many, 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 many years, had lots of managers apply it, and it only really gets applied if usually in an argument where an employee gets in an argument with another employee or a customer who shows up at the building department desk, and profanities start getting flung or whatnot. If people say, I support Trump or whatever, that's not, you're never going to get anybody disciplined for that rule. So
Correct.
it is generally worded, but that's where the reasoned application from the leadership team will come in, where they're not going to discipline somebody unless they truly are deserving of it, knowing that, if the person doesn't like it, then they're going to show up to this body, and this body's going to say, manager, what are you doing? That's not how we think that rule should be applied, so I'd leave it, my recommendation is to leave it the way it's written.
I agree. So, sorry for.
no, it's all right. We're going on to page 105. let's see, it's Section 11, discipline and discharge, item C, progressive discipline.
And there's no, the tracks and the steps follow what's currently in place, or?
No,
Or is it
this
not?
this is a.
Totally more well
This is a
defined.
clean sheet.
Yeah.
Okay, no, I
Way
was
of
just
doing
curious.
This is more well-defined.
Okay,
Yeah.
good.
Because I don't think the progressive discipline and the other, as a matter of fact, I don't think there's much in there about progressive discipline.
There is and there isn't. It's with each group defense.
Yeah.
So with each group discipline, it says oral, written, or discharge. And as you go through the groups, like 4 would be straight to discharge.
Yeah,
But I agree. I think this is worded better.
yeah, it's worded better, yeah.
Good, I'm fine.
I'm good.
Okay, so item 11, let's see, so page, I want to make sure I'm right, yeah, okay, page 107, it's section 11, discipline and discharge, item D, appeal process. I got a couple questions on this one, Mr. Eschenfelder,
Yes, sir.
and I want to get to my notes. And I know that the Civil Service Commission has decided that we'll use appeal versus grievance, and inside of the charter, it's listed as a grievance. And the commission decided to go with appeal as the word that would represent that. It's not defined, but I know that's what we're doing here. There are a few places in here, Mr. Eschenfelder, where it actually reads grievance and not appeal. So as we get to those, I'll point those out.
Okay.
But in this, and I'm concerned that I have missed it, and because I've read through a couple times trying to figure out where to go. And when we get to a certain point, and it gets beyond Mr. Gomez's position, where if the person still wants to appeal whatever's happening, when we had our joint meeting between Civil Service Commission and the Board of Commissioners, we decided that there would be a magistrate, I believe, that would resolve those type of issues, so it's not the Board of Commissioners, and it really takes it to a level where it's just official. Did we follow our rules? But I don't see that in here.
That's because that can't be in here, it can be, but because of how the current code is worded, the code needs to be amended, so it's going to be in the code. So when you see the ordinance in your next meeting, that is where you'll read that new.
But that's why I don't see it.
process,
Okay,
yes.
all right.
Yeah.
So then
And
the only
just
thing,
for the new commissioner's benefit, the process that this commission had a joint meeting with the Board of Commissioners, and after discussion, the Board of Commissioners felt that the model that they would like to see is that we would contract with one or more attorneys that are qualified to hear these kind of matters, to sit as sort of a special magistrate, and the termination appeal would go before that particular individual. He or she would write a recommended order that would then come to the Civil Service Commission for review, and you guys, you couldn't reopen the trial, if you will. The factual findings are the factual findings, but then you all could decide, based upon those factual findings, do we agree or disagree with the magistrate? And then that would be the end of, you would be the final stop in that process,
Right.
other than court.
that would be
Would
provided
we
to
need to change the
Board of
charter
Commissioners.
to put that in there, or?
No,
No,
To change that word?
we were
you
trying
would
to.
not need to change the charter.
Okay.
Okay, I'll point out the various places where I saw grievance as we get to it.
Mhm.
Okay. And we don't need to define that appeal represents grievance in this case, correct?
So, as we've discussed many, many times, and I know you may disagree, the word grievance is a largely union contract-driven thing. It is addressed in a completely different section of this policy where you can file a complaint about the air conditioning is too cold, or, all those kind of things that are not discipline-related. In the world of discipline, I just think using the term appeal is the cleaner way. It's the way judges are used to nowadays. Because when you talk about an employee grievance, that could be many, many things that have nothing to do with being disciplined. If you're disciplined, you appeal. If you're unhappy with some work condition, you grieve it.
Understood.
Yeah,
And I
makes
get
sense.
that in the union world, you file a grievance as your first stop in complaining about discipline as well, but I'm trying to sort of modernize our language the way most of the world now operates, at least in public
That makes
employment.
sense.
Thank you.
That makes sense.
We're still on appeals process, okay. XI-8. There we go.
So would a 2-day no call, no show, does that fall under,
That's a resignation.
that's not job abandonment? Or is it?
Yeah, that's what I call job abandonment, terminum.
So that would not be appealable? According to this, it says that that would not be.
Y'all aren't telling me where you're reading.
Oh, sorry, page 108, sub E. Employees may not appeal letters confirming job abandonment.
Right, so earlier in the rules, you saw that an employee who fails to show up and fails to call or let us know or whatnot for 2 days in a row are deemed to have resigned. And so obviously, you don't appeal a resignation, and so that's why that carries over to this, to say, if that's the case, that's not discipline, you can't appeal it. Now, you can go to the manager and say, manager, I showed up 4 days later after falling off the face of the earth because aliens came and grabbed me. Here's a picture of the aliens, I can prove to you, and the manager can say, fine, I believe you, great picture, you're back to work. But that's not something that you, it's not a discipline, it is, you didn't show up to work and so you're deemed to have resigned.
Understood. There could be situations, though, where there's a dispute on whether the person had approval or whether someone knew, so. I'm fine with it, but
And
this.
in like and I hear you, I mean, since 1996, when I started doing public employment law, I've had that occur maybe 2 or 3 times, and if the employee came in and really truly had a good reason why they just couldn't reach out, or a lot of times what happens is the employee says, oh, I did reach out, I left a voice message for the assistant, in this other department or whatever, and that's why, when you get over into department-specific rules, some departments will say, okay, I'm done with all this monkey business of calling out this way or that way. To effectively call out, here is the thing you must do. You must call this person, you can't text anybody. And I leave that up to the departments because every department runs differently, so you don't want to necessarily hem them in there. But if it comes to that kind of situation and the employee, and there's no good solid rule that we could point to of a process, and the employee says, I left a voice message for Susie. Or I called Clara and Clara said, all right, I'll let the manager know, whatever. Then if we can prove that, then okay, you did not resign, you did reach out to us. Shouldn't have done it in that sloppy of a way, but nevertheless you did. But if you got nothing, if you're getting that letter, and it's usually because 90% of it is they're in jail, and the other 10% is some sort of a bender that they were on. Either which way, they're deemed to have resigned.
Yep. You okay, Dr. Tilka?
I'm good, yes.
Okay. Clearing. I believe we are up to page 111, item 12, employee complaint procedure.
And this is what I call the grievance procedure.
I think this is probably the sections where I saw grievance, and that, to me, would, right? That's what
Yeah,
you-
that would
this
be
is the-
consistent,
yeah.
because this is what I call the grievance procedure.
Yeah, yeah.
Should 3, the regular employee, say a person employed by the city who's not working in a probationary or temporary status?
No, well, we want our probationary employees to
able
feel
to
that
make
they
it.
can grieve something, you know? I mean, even if I'm still on probation, if the
Okay,
air
so this
condition-
is just complaints, not appeals?
Yes,
Got it.
this isn't appealing
You got it, okay.
termination or discipline. This is a workplace complaint or problem, which I can still experience as a
On day one. I
probationary
get it.
employee, yeah.
I'm good.
Dr. Tilka?
I'm fine.
Page 112, section 12, employment complaint procedure. Item B, general provisions. I totally understand what you're saying about grievance now, because where I'm seeing grievance makes sense that it reads grievance. Yep.
Now, in that chapter 50 where it's in the red, now they can also make that complaint to a state agency, couldn't they?
Yes, of course.
Because I think that one is just for certain.
Which one, Claire?
Page 112? Is that the one, Claire?
112C?
Yeah, it should say, under that code or directly to,
Federal, state, or local, no?
So Claire, I'm confused because I'm reading this. You're saying besides this, they can report it directly to the state. Is that what you're saying? But this references,
No, so on my recommendation, the city commission adopted an ordinance that created a new section of code that is a whistleblower provision that allows any city employee or any city contractor to blow the whistle on any of these things. There's a companion state statutory scheme, which you're aware of, the Florida Public Employee Whistleblower Act. And so one of the reasons that I recommended that the commission create a code section is to give employees a clear step process of how it's to occur, and then also to distinguish what if the complaint is against the manager, how is that looked into? So that's all addressed in the code now. But one of the key things is that employees under the statute, employees can't sue the city for violating the Whistleblower Act unless they follow the procedures of the Whistleblower Act. And so what I wanted to do with creating this additional reference is to never let us be accused of hiding that provision because it's in the code. So I'm cross-referencing it here to say, guess what, guys? If you've got a complaint about whistleblowing, there's a section of code, go look at it and follow those steps. And if they choose to, that's fine. They're protected and all that. If they choose not to, then they aren't able to sue us.
so if they go directly to the state, they cannot,
I
there's
think
no,
it says it in there.
Well, they can go directly to the state, but if you read the statute says if it's a local base, then where you need to file it with is the local CEO.
Understood.
And
Okay.
so in our code, of course, then it came up, well, what if the manager is the person being accused? And so, my ordinance took care of that to say, if that's the case, go to the mayor, the city attorney, the two of those guys will figure out what to do. That's all dealt with. So this cross-reference is really mostly in the policy, just to point people to, if you've got a whistleblower thing, there's some place to go look up, here's where you look it up.
Right.
Understood. Okay, good.
Are we ready to move forward to procedural steps?
Yep.
Okay. So page 114, item 12, section 12, employee complaint procedure, item C, procedural steps.
Okay.
I'm good, but now I'm confused about grievances versus complaints. So in that added, at the very last subparagraph 4, the civil service shall receive quarterly reports of all grievances.
There, okay. So you went on to D.
So is that,
Okay, all right.
I just want to make sure that
That's,
it should be grievances there?
that's what I'm understanding. So he moved ahead onto page 115 on subsection D. Are you
Oh,
okay
sorry.
with that?
I
It's all right,
did.
I get it. It blends together. You okay with that, Dr. Dilton?
Where are we?
On page 115,
Yep.
the red area,
Okay, yeah,
underlined.
Got it, okay.
So the Civil Service Commission shall receive quarterly reports of all grievances within the prior quarter, setting forth the nature of the grievances, the resolution, whether the grievance was processed according to the time limit set forth in the section, and indicating whether the employee agreed with the disposition. So this grievances was the question, correct?
Because we're talking about complaints now, right? Or no?
Complaints.
Or was that-
Right, so what setting aside the termination cases that the Civil Service Commission will see that come from the special magistrate, this language was added because when the Civil Service Commission was talking about this section, they were like, okay, well, so these grievances are going to be administratively disposed of, but we'd still like to know how are employees making use of this? Are there grievances being filed? Do we see patterns here? Because part of the Civil Service Commission's duty is to help the to recommend policies or whatnot. So by seeing quarterly reports of what grievances may have come and how they were disposed, that might help the Civil Service Commission to recommend further policy tweaks or additional benefits or whatever it is they may see based upon the grievances. Is that a fair statement?
That's correct. The other side of that is, as a commission, we were clear that we did not want the employees coming to us to tell us the air conditioning's too cold.
Right.
So they come to us because there's a disciplinary action and you didn't get satisfactory resolution, all right? But they got to be able to support it. This is it being handled internally so that way we know, okay, do we have to address this in a different way?
Are we seeing patterns here or something of a bigger picture that might need to be addressed?
This
Should
would-
that, should that really be a separate section? Because I know it's thrown in with retaliation, but it's really kind of a separate,
So that'd be.
should we make it E is all I'm saying?
This would,
An E?
would this not have to go to the level of a magistrate? It would be all grievances.
It's just the air conditioning's too cold or
Yeah, everything.
this didn't get fixed in a timely manner, or I didn't like that I only got 12 minutes of my 15-minute break. That would be that type of stuff, correct, Mr. Gomez?
Yes.
Could that be made a separate section? the Civil Service Commission oversight? Just
Yeah,
make
I
that
mean, you're
section-
creating another page for one little sentence.
Oh, is that, well, no, it's fine. But it's totally unrelated to retaliation, that's all.
So I think it's easier, I'll just change the subtitle to say semicolon, periodic reports to the CSC.
No, good.
Is that all right?
I'm
And
good.
we're leaving it grievances as opposed to complaints. Where it says, receive quarterly reports of all grievances.
Do you want to
But
do,
is that the same, I mean,
that's,
was that one of the ones you were raising?
that's where I want to make sure there's no confusion with what the wording is in the charter. That's the only thing I would be concerned about.
All right, so I'll just make the word complaints instead of grievance.
Thank you, sir.
And what section are we changing that in?
Page 115, item D,
Okay,
Civil Service Commission oversight will be changed to periodic reports to the Civil Service Commission. And then the red bold area, the word grievances will be changed to complaints.
the nature of complaint, okay.
And grievance is in there 3 times.
Okay,
That's
thank you.
correct. So there's 3 spots in there, it's got to be fixed.
Yep.
Thank you, sir.
Got to do something.
Okay. Are we okay to move forward? Yep. Dr. Tilka?
I'm ready.
Okay. Section 13, illegal discrimination or harassment. Can we lump a couple of these together here, guys? Would you be okay if we did A, B, and C together? A being policy, B being definition, and C being procedure?
Okay.
Are you okay with that?
I'm good.
Yeah, I can see this is complicated, but I'm good.
Yes, it is.
Do we feel like any of this is maybe too broad?
Do you think it was too broad? I think that's what you said.
It's-
I mean, I'm seeing. like-
These policies are incredibly difficult to administer, but by its nature, it has to be broad and specific all at once, and it never is enough, but, was there a part that you were concerned about, or?
I just going through and I was like, wow, this, it's extremely broad in regards, like a joke.
This
If
is,
somebody
this is
takes a
job
joke-
security for attorneys.
Okay, so tell us about that. I mean, how do we get maybe this is fine.
Well,
That's what I want to say, but,
I mean,
anybody can take a joke one way or the other, it's a joke. And,
I'd be curious, but the problem is that anybody can make a federal case out of that. And so whatever, this policy matches what
It's what we
court
need.
decisions say.
Okay.
And we need to do it to protect the city needs to do it to protect itself.
Okay.
Whether a joke rises to the level is going to be what happens after the investigation, right? So, So yes,
And we have to go along with something there, but I just,
this is, this is boilerplate, but yes, unduly vague and broad for sure.
I'm okay.
Sounds like there's no way to really make it
Yeah, no. that's
everything
not-
you want it to be.
Not unless you want it to be 10 pages, and then even then, someone's going to find a way to
Little
poke a
loophole.
hole in it.
Yeah. Are you okay to move on?
Yes.
Okay, so we're going to page 119, section 14, labor management relations.
Good?
I'm good.
Page 120, section 15, employee recognition program.
Okay. I'm okay with that.
Good.
Page 121, section 16, employee performance evaluation system.
I'm okay with that.
Is this what you were talking about earlier? This is based on the anniversary year?
Correct.
Does it need to say, I don't see where it says that in here, and that's fine, as long as we're good with it, or there's a separate procedure that says that, I guess.
I don't know if there's a separate procedure with evaluations. I'm fine if we want to put language in there that it's on the anniversary date.
I think you should just leave it as it is, because if that changes, again, I'm trying not to put little details like that, if a future manager wants to change how it's done, now we have to do an ordinance to change, and then we have to hand out brand-new personnel policies to everybody, just because we changed that one thing. So
Right.
I think this contemplates that there will be a more detailed evaluation procedure that the manager promulgates, that evaluating supervisors and managers have to understand and apply and follow in a consistent manner. And so when those evaluations are done, whether they're on an anniversary date or calendar year or whatever, that's a kind of an administrative thing that we would leave to be adopted.
Can I ask about number 5? In the beginning, under the HR report, you indicated that you're going to be going to electronic
Yes.
performance appraisals.
Yes.
Item 5, can we modify that slightly to where it reads either forms, either database, I don't know what that is. I don't want to get stuck with forms if somebody says, hey, look, it's supposed to be on paper.
But it is an
Those
electronic
forms,
form.
is that an
When
issue?
the data is put in by the supervisor, the output that a viewer will see is a form, and that form, if we get into litigation or whatever, it will be printed out, and so it will say evaluation, it could be converted into a piece of paper.
I see what you're saying.
Correct.
Okay, understood.
A form.
I got it, okay. All right. So what I was concerned about there is that if you're saying form, it doesn't match, but you're saying it is, that's what it is. I get it.
It's an automated form.
Okay, got it.
Fillable form.
All right. Okay, are we okay to move on?
Yep.
Page 122, section 17, outside employment, enterprise, business.
I'm good.
Okay. Page 124, item 18, political activity.
Okay.
There's a separate social media policy, right?
I believe we did have a separate social media policy, don't we? Mr. Eschenfelder? We talked about,
Yeah.
I don't remember if it was separate or it was inclusive, but we talked about social media at some point.
I have a separate social media policy that I give my clients. Ms. Powers, did we?
I
did
thought we were going to do it separately.
Well, we were going to do it, but have I given you one?
I don't believe so.
All right, I'll,
Well, so on
Give it.
page 156, there's electronic communications and social media. And so the only reason I just want to make sure that those two live, live in peace with each other, because I saw the addition on page 124 to online, that's talking about advertisements. We might want to reference, only because political activity can happen on social media. That's the only reason I'm raising it. So I don't know if we want to cross-reference it or if it's fully addressed in the social media policy, but in today's world, social media is where a lot of this stuff happens, so. Yeah, so the electronic communications and social media policy is mostly electronic communications, right? And then the social media is kind of included in there at the end, but. Okay, no, I just want to make sure I understand what's all out there, but the political activity issues definitely come up or trip over whatever's going on social media, so that's. Because if you look right now, under that subparagraph 3, where it lists, however, no employee shall take part in political campaigns, use the authority of their position to support or oppose a candidate, use any promise or reward or threat, display on their person or vehicles, appear in any print, television, radio, or online or other form of advertisement. I think that's fine. We just have to realize that employees potentially are posting or commenting or doing stuff on social media. As it's written here, I don't think it conflicts or prohibits that. It was that online reference that triggered it.
I think
for
the
me.
only thing here, it says while on duty. So if they were doing that on their own personal Facebook during their duty, then it would be an issue. But other than that,
I'll just add the word social media before the word online. So it would be radio, comma, social media, comma, online, or other
Sure.
form. That, okay?
Sure.
Sure.
Can we go back, so what were you saying about during work time or what?
For here, it's, da-da-da-da-da-da. I guess it's mostly the social media. If they're doing, I guess it would be hard to quantify. We'd have to look at everyone's social media to see if they did it during duty.
No,
Yeah.
these days, however, people's off-duty social media can affect the workplace and can affect other employees, but I don't want to make it complicated. I just wanted to make sure we knew what online meant, or if that included social media.
So what, all E really gets to is we don't want you wearing a Madeira Beach uniform if you're going to
If you're gonna
be
be making a statement.
appearing in print, television, radio, social media, or online. Because you're given your uniform to do your job, not to endorse a candidate or any whatnot. In terms of outside of that, what employees do on social media, that would then go back to those 61 discipline
Right.
rules.
Or the harassment discrimination policy.
Well, or that too, but,
Right,
you know, so like, for instance, on or off the job conduct, you know, which would adversely affect your coworkers, you know, blah, blah, blah. So if you, during your off-duty time, take to social media and do horrible screeds against your coworkers, you know, that may get you to be disciplined. But in each of those kind of cases, because there's an intersection with the First Amendment, you know, staff is going to call me and say, here's the facts that we have, you know, what's the case law say on it? And because, you know, there's issues there. And there's also, on the labor law side, you know, what is concerted activity? You know, if you're complaining about your job conditions. So those will be very fact-specific. But, you know, I mean, I had, back in the day, a legal assistant who put some social media posts that were overly risque and put my office in a bad light, and so that had to be addressed, you know, but we want to take the default as government that our employees are fully able to engage in vigorous First Amendment activity, and we want to understand and respect that their off-duty time is their off-duty time, but we also want them to be cognizant that even if you're off-duty, if you do things that go too far, depending on your rank, and that can factor into it as well, if a department head does
think
it
it's a super
versus,
rank.
you know, then that'll be factored in. But anyway, I think, at least for your.
I'm good. I just wanted to make sure
I have
we're aware of those issues that are happening, and they're going to happen between now. Won't be for this, but between now and November.
Oh, goodness.
something that's not party lined either way, let's say open carry or other things that are going through our government, people having an opinion on that. Is that political if it's not party aligned?
You're free to take to social media or whatnot and say, I think so-and-so should be elected to the Madeira Beach Commission. That's your First Amendment right. But what you're not allowed to do is put on your city uniform and go stand behind that person in a promotional video for his or her campaign, because that's misusing your position as a city employee. You got to keep that completely separate. So wear your civilian clothes and do that all day long, as long as you're on your non-duty time, perfectly fine.
Those longest employees, I'm certain will note that. I'm okay with it.
Common sense.
Which is
okay,
also
okay,
job-
that's
which
right.
is also job security.
Yeah.
The lack of common sense.
Fleeting.
I'm fine.
Yeah. Are we okay to go on to 19, safety?
Yes.
Okay, page 126, section 19, safety.
Easy.
Okay.
I'm good.
Okay, page 127, section 20, drug-free workplace program, A, purpose, scope, and prohibitions.
And pretty much all the way through page 144
Not this-
is a drug-free workplace program, which is largely driven by all of the regulations that apply. There's some state regulations where language is bolded, you non-new members already know where language is bolded. That's because that also relates to federal regulations. There's a Motor Carrier Act that applies to some of our employees, FTA rules that apply to some of our employees. So unless anybody has specific concerns or questions, it's a pretty standard drug-free workplace program.
I'm good.
I'm good.
Okay. Page 145, section 21, professional development.
I'm good with the drug-free workplace policy, but it's too long, no. It needs to be long. But we got through a lot of pages there.
I think we have 15 pages left, guys. We're
That's
gonna
good.
make this.
No kidding. I can't believe it.
This is, and I'm like,
My heart's pounding.
I'm sitting here, I'm
Been
like,
with
oh
my
my
stupid
God.
questions.
We just needed Commissioner Paul here to,
Yeah, like
I'm
right
trying
now,
to slow it down, so I asked questions. Otherwise, I feel,
I'm feeling this significant sense of accomplishment right now. This is huge. I wish she was here, and I wish Judith Ann and Christine were both here, because huge contributors to this.
Oh, yeah,
That's-
definitely.
Okay, all right.
professional development.
Page 145, section 21, professional development. And I don't know if anyone has comments on this, but I can tell you, I think we discussed this very well, and we tried to make sure people that wanted to get non-degrees could work
Yeah,
on
we
non-degrees.
did.
People wanting degrees could get degrees.
Did-
I'm good.
I'm good. Yeah.
Okay. Page 147, section 22, travel time.
I'm good with that, too. Don't see anything different.
Mr. Gomez, and I'm probably looking in the wrong spot, but we had discussed that the city's reimbursement for, was it mileage? Is that right? That there was an issue with that?
There was an increase, so I had a new form made.
So that's not this, though, it's a separate, right?
yeah.
Okay.
travel
good.
time means pay. Reimbursement
hours,
for
correct.
expenses
Yeah.
is a separate.
Okay.
So it's kind of fine to put in, but usually I don't put in exempt employee. I mean, they're getting paid their salary regardless, right? So it's a little confusing, one, to have it in there, I think, and then to say it's compensable only when it occurs. I mean, there are no regular working hours for exempt employees, but,
Yeah.
I mean, do we need it?
It's like a reverse way of saying you're not getting paid for travel time, just because you fly to a conference and, you get more pay because it stepped outside your quote-unquote normal workday. But I'm fine with taking out two. It's not really essential to me.
Dr. Coco?
I don't have an opinion. Let me read it again.
Because it says it's compensable only when, I mean, they're still getting paid their normal salary, right, regardless.
Right. It's more to say, don't make a claim to us
For
for
extra.
anything more because you traveled
Right.
overnight or whatnot.
Right.
But let's just take it out.
I would,
mean,
yeah.
I agree.
Get paid for the actual mileage.
Okay.
So item 2 is being removed?
Yes.
Yes.
Okay.
Item 2 is removed.
Yes, ma'am. You guys okay to move forward?
Yes.
Page 148, section 23, workplace violence and threats.
I'm good.
I'm good too.
Okay. Page 149, excuse me, section 24, uniforms. Are you okay, Dr. Sokol?
Yes.
Okay. So we're now on page 150, which is miscellaneous policies. There's a lot here. So is it okay if we just take these one at a time? It'll be quick. We'll snap through them. Is that all right?
Yep.
So A, departmental rules, page 150.
Okay.
So it says reviewed by the Civil Service Commission and issued, does that mean approved? Is that, or is that different?
What was the intent there?
Issued is by the manager, because this is
okay.
one of those administrative policies.
We want to be able to have the ability to make sure that it conforms to this.
Okay, well, so do we need to say something more than review? Because right now, it just says reviewed by, does it need to say reviewed and
Okay.
and approved,
No,
or no?
because in this setting, that the Civil Service Commission does not have power to tell the manager, no, you cannot. It is a consultatory thing where the manager is required to bring these things forward, and the Civil Service Commission is going to say, well, could you change this? We recommend that. But at the end of the day, if the manager says, but I'm going to promulgate it the way I want to promulgate it, he is the manager, and so if it's an administrative rule, he gets to do it. If the Civil Service Commission vehemently disagrees, which it could, I think this manager is very reasonable, but a hypothetical future manager who says, I hate you all people, I'm going to do what I'm going to do, your power is to say, I adopt a resolution that goes over the manager's head, and I'm sending it to the commission, saying, Commission,
that
we
in
do
the
not think this
code.
should be an administrative rule. We recommend that you instruct your manager to rescind that rule or to word it a different way. And because he does report to them, they would address that issue.
Okay, should we say then, reviewed by the Civil Service Commission and issued by,
By the manager.
our department director, or whatever the right terminology is?
And
Okay, I got that.
Okay,
Okay, I'm good.
good. Item B, general appearance and work attire. I'm good.
Good.
Item C, city property and supplies.
Good.
Item D, city communications equipment.
Good.
Item E, address and telephone number.
Good.
Page 151. Item F, solicitation of contributions, memberships, or business.
Good.
Item G, statements by city employees to attorneys, law firms, or others concerning employees or city business.
Yeah, and it's certainly implied in there. Do we need to say something about or filing an agency complaint for discrimination or anything? And I hate to say that or invite it, but the EEOC would look at that and say they're not included, but
So what's the recommendation there? I read this and you've referenced a Florida statute, but there's the word grievance there. Does that need to be there because of the statute?
That's the phrase used in 447.
And it needs to be there, correct?
Yeah. So I will add comma, or filing an administrative complaint with any state or federal agency.
yep, I think that covers us generically.
Okay. Item H, media relations, request for interviews.
I'm good.
Good.
Or wait, so, well,
Yeah.
so this, it continues there.
Yeah,
There's a
it's
sub 2 and 3.
It's just a pagination error. Page 153, item I, recording workplace communications prohibited.
I'm good.
Item J, loss of or failure to obtain professional certification or license. Did you say okay, Dr. Tilka?
I'm good.
Page 154, item K, searches on city property.
I'm good.
Item L, employee arrest or charge.
Good.
Item M, use of tobacco and e-cigarettes. Mr. Eschenfelder, is e-cigarette going to be good enough to cover all the vaporizer-type products? It's hard to know. I don't know the
Yeah.
answer. The intention
What
is that,
other phrase could I use?
I have no idea.
Not being a utilizer of those products, I don't really.
I don't know either.
It is in quotes, so we can define it how
So that would work?
I think it covers it.
Yeah. Yeah, but there's, yeah. He just said, yeah, he even said that it, because it's in quotes, it references the.
Unless we wanted to list out all, which
I know,
I'm not an
I'm sure
expert
there's
either.
500 words that could be used there.
Do we want to add in city vehicles? I think it only really says buildings.
Yes.
Well, there's a separate section on city vehicles, and it may be in there.
Okay, so do we need a reference in that section that they can't use any type of e-cigarette in the city vehicles?
Plus, I'm quickly flipping over to, city vehicles is the very last section, so I want to say it's, smoking is addressed in that one.
Yeah, it's number 12.
Oh, it's there, yeah, 12, it's there.
But should we put e-cigarettes in quotes?
All right.
Consistent. Or smokeless tobacco, okay. Well, I mean,
See, the problem there is it didn't necessarily, because they're nicotine products, not necessarily, and they don't have to be nicotine products, they could be other type of products.
I'm adding the word "or vape product" to both M for the use of tobacco
Okay,
and 12 in the vehicles, and that way it'll even be more broad.
God, and I'm sure, just like you guys are saying, someone's gonna find a way around it.
I know.
Yeah, that's, or vape product. Okay, so we are up to, is everybody okay to move on to N? N is city bulletin boards and common areas. I'm good. Joka? You're good? Okay. Page 155, item O, communicable diseases. Good. Dr. Toka? Okay. Page 155, item P, inventions and intellectual property.
good.
Item Q, letters of reference.
Good.
Item R, funds owed by employees' debt collection calls. Oh, that scared the crap out of me.
Okay, we all know that there's a warning.
Oh. Well, I know my heart works. There we go.
So it's not a big deal. Usually what I say is the employer is otherwise authority to retain or otherwise withhold portions of an employee's compensation, including from a final paycheck. There's special rules for a final paycheck, so can we add where it says portions of an employee's compensation, and then put in parentheses, including from the employee's final paycheck. Assuming that's what we want to do.
Can you tell me where your,
Yeah, our,
are what?
Where
third
at?
line,
Third line?
Third line?
yep,
Ah,
portions of an employee's compensation. And then I would add, including from the employee's final paycheck. Assuming we do that, I don't know if there is something to withhold, do we do it from a final paycheck?
We try not to, but yeah, there can be.
But it gives us the right to if we need.
Okay, got it.
You okay to move forward?
yeah.
Dr. Tilken? Go ahead.
Having trouble understanding.
You're talking R?
Yeah. I mean, who has the authority to withhold pay?
City.
For their benefit, not for someone else's.
Correct.
Yeah. Yeah.
Can't be
If the employee for some reason owes the city funds, and then you quit, we withhold that from your final pay, so long as we don't reduce you down below minimum wage, because we're not allowed to do that.
I was reading and thinking maybe a debt collector could.
No, we don't get into the business of collecting for other people.
You okay then?
Okay.
All right. Page 156, item S, electronic communications and social media.
And Commissioner Tilka, just so you understand, there's a Florida statutes chapter on wage garnishment. So if other folks wanted, we have to get a court order that says withhold this person's pay and send it here, then we would do that.
Child support or a bank or a loan or a credit card.
Garnish is what it's called, garnishing wages? Yeah.
So just so I understand, you were talking about, so when I asked about social media, you said that you could provide or there's a separate, so that's not this, or?
No,
Okay.
I've developed one, that's not this. What I'll do is just make sure that what I've developed separately, if it's not in here, I'll put it in here to beef it up.
Got it. So when so what's currently in here, the subparagraph 8, when it's talking about misusing social media, is that referring only to
The city's
City
social,
city
yes.
social media?
Yes.
Okay.
Absolutely.
So I'm fine with this, but should we change the title then to say electronic communications and use of the city's social media? If that's,
I'll just add the word city in front of social.
yeah. And then we would do, what you're
Right.
saying or contemplating is adding a separate personal social media policy, which is not in here currently.
Correct.
Okay. So I'm fine with
Next item? Next item, okay, page 158. Section 26, use of city vehicles and use of private vehicles for city business.
See, you jinxed it by saying we were going too fast. So, looking at 13, drones caught my eye, but no city employee shall order, authorize, or permit non-city employee, including contractors, to operate any city vehicle, including cars, trucks. Okay, so drones was added there, does it need to be added? I'm just asking if that needs to be added or
We have,
defined.
the fire department has drones, and there's specific laws that apply to, I'm a licensed pilot, so there's specific laws that apply to flying those, and that you can't just fly them, and you can't tell somebody to fly them outside of the way the laws are currently written either, so that's,
Is there a definition for city-owned vehicles, or it's just
It's the plain English doctrine.
understood?
It's a
Okay,
vehicle
well, I know,
by the
but,
city.
but then when I saw drones, I'm like, I wouldn't have thought.
Look, that was, obviously, because it's in red, was added by the Civil Service Commission.
Yep, no, I get it.
It doesn't, it's not, arguably not really within the wheelhouse of this chapter, but it's a fine enough concept that if we do own drones or aerial vehicles, that we shouldn't be handing them over to non-city employees to operate.
Yep.
Well, it's really kind of the reverse. If one of our employees is operating a vehicle on duty as a city employee, the city is liable. Well, a plaintiff attorney is going to sue everybody. He's going to sue the truck manufacturer, the tire manufacturer, the individual employee, whoever they can find. But ultimately, because it's the employee, if the employee was in the course and scope of
And
his or
following
her
the rules.
duties, and following the rules, then, the employer is going to get stuck with the liability usually. The employer can try to get out from under it by saying, well, they may have been in a city truck and they may have been quote-unquote on duty, but we didn't pay them to do 120 miles an hour over the Skyway Bridge because they have no duty in Manatee County anyway. So they're on their own, I mean, that all gets settled out in court. But generally speaking, we're going to get sued if there's a city employee in a city vehicle who hits somebody or injures somebody.
I'm good.
okay. We have, for our projected time, we have 10 minutes left. So can we what's realistic on getting the revisions done? I want to know how quickly
They're
we can
bringing
get
back
this
a
to the
AI
Board of
policy we
Commissioners, is what
haven't
I'm
seen.
going at.
Well, when's the next commission meeting?
3 months.
We would need to have one in October, because you pick your new officers in October. That's in our code. So we could do
I
something
thought you
then.
were asking about your civil service commission or city
No, get
commission
this-
meeting?
The document,
Yeah.
how quickly can we get the revisions
Oh, to have another civil service commission meeting?
to have another Civil Service Commission meeting so we can get this approved and it can go to the Board of Commissioners?
Well, I
'cause
thought
it's
this is approved.
Huh?
I thought this is approved.
No, I think there's an AI policy or something
Well,
coming
that's a
forward.
separate
and-
policy that's not within this.
Oh,
What you were going to add?
So, timeout.
Yeah.
So how I would suggest is, you've given me some additional tweakages, but tonight's instruction is, we approve with these tweakages. At the next Civil Service Commission meeting, we're going to see two things. We're going to see the final clean copy of this, and you guys can still make changes, but hopefully you won't. And you'll see the ordinance that adopts this. And then you vote, okay, send this ordinance with the attached policy to our commission.
That
it
sounds
goes to a
wonderful.
workshop.
Now, that being said, I do have a couple of employees that had some statements on the handbook, and I do have a list that I wanted to present to you, as well as the Civil Service
Yeah,
Board. But they wanted to see what you guys wanted within the handbook, if you will.
Is that tonight or is that?
Yeah, once we're done with this, I'll send that out to them. And I know that finance already has a
Oh,
couple things
this.
for me.
Okay, I see
Yeah,
what you're saying.
yes.
Okay. Now I understand. Okay. So do we need to vote to say, yes, we approve this with amendments, or how do we go about, what do you need us to do at this point?
Well, I don't know that you need to vote. I think what the minutes will reflect is that I'm sorry, I was waiting for the minute taker. So I think the minutes would reflect that the Civil Service Commission has made final revisions to the policy, has instructed the attorney to put the policy in final form, and to bring back the adoption ordinance for its next meeting for final approval of both. That's what your instruction is. It doesn't need to be a motion.
Understood. Because Dr. McLaughlin's not here, so how do we just need to pick a date in October? Is that correct? But how much time do you need to make the changes before we pick the date?
I could have it to you in 2 weeks.
2 weeks?
And I'm
So
at a conference the third week,
You're at a conference the third week, so the last week of
or
October?
the week of the 14th.
Does that work for you?
What day?
Check the calendar.
The 29th of October? Or the 30th?
31st is not good.
Or the 31st? We get dressed up in costumes if you like.
What about?
We're serving candy here.
What about the week of October 21st?
Let me see, October,
21st,
The
22nd?
23rd is a BOC regular workshop.
Correct. So the 22nd of October, Tuesday?
I'm fine with that.
I could do that.
Could we, to give Judith Ann more time, can we set this for, say, like 3:30 or so?
It shouldn't take nearly as long, so sure, yeah.
Yeah.
I'd be surprised if we take more than an hour and a half for everything that
We're
day.
gonna
So
do
maybe
our
4
officers.
o'clock?
Would you like 4?
I mean, just to give her some time.
Time.
But that's up to you, just a
So
suggestion.
okay with
October 22 at 4?
October 22 at 4, are you okay with that, ladies?
I'm good.
Yes.
I don't think we have anything.
24, 2 PM. Okay.
All right, it's exciting.
4 PM.
Oh, crap, 4 PM, thank you.
We'll do our officers first, or after, it doesn't matter.
And 22 at 4.
At 4 PM. Yeah. Okay.
And just so you're aware, there is only one meeting date of the city commission in November, and also only one meeting date or meetings date in December as well. And those dates are November the 13th Wednesday, November the 13th, the commission regular meeting is at 2 p.m. and a workshop at 4 p.m. And then on December the 11th, a commission regular meeting at 2 p.m. and a workshop at 4 p.m.
And what time is the meeting on November 13th?
2 p.m. is the regular meeting and the workshop is at 4 p.m.
Which this goes to workshop or
So it would need to go to a workshop, and so the earliest would be Wednesday, November the 13th, beginning at 4 p.m.
yes.
That's the next commission workshop.
Is that a joint meeting? Or,
No, it's just.
No, it's just a
No.
commission workshop.
You're done.
okay. Good. I'll be there regardless, but good. Accomplished.
Y'all did a good job.
It was a lot of debate. There was a,
You added a lot to the thing.
I don't know.
Great.
I don't know, Mr. Eschenfelder had to catch me up pretty quick. That was,
Sounds good, man.
Well, listen, Chair Cantrell, you've been handing out compliments to other people, but I want to say, when you took over, you really did accelerate the process, so I certainly thank you for bringing this in for a landing.
thank you. All right, so let's, old business, we've touched that. Are you guys okay to just quickly address future agenda items? We're not going to address them today, but we still need to go through the ordinance 2407 with amendment to the Civil Service Commission rules, review changes after personnel policy procedures. I don't think we should do that on the next meeting, but the following
Right.
after that, because we have this done
That
now.
is what we were just talking about.
No, this was different than the policy.
Correct. It's different. That's their rules. They got to
our
write their
rules.
rules.
Okay.
I want to.
Our procedural rules.
These are our rules. Yeah,
That needs to be a work session by itself.
yeah, that does. Yeah. So that's,
That's your rules.
but that, I think we're meeting in December, if I'm not wrong, and that's probably
think
where
so,
we'd
too.
address that, because we agreed that we would do this after we finish this policy. And then, item B, implementation process for making sure the rules, that's going to be another thing, that'll have to come later. But it's one of those where we need to figure out how are we going to go through and verify, are the things in the policy actually happening? Department-specific rules are one of those things that we just need to see what the department-specific rules are so we can assure that they're uniform and they don't contradict what we have in place. Employee satisfaction surveys, you're already working on, is that correct, Megan?
Yes.
Okay. Separation survey, you're working on as well.
Yes.
HR director position, address after personnel policy is adopted. And I know that we're going to have a discussion, but I've got to talk to some people and verify how do they want that addressed? Because it's where the position is located right now, not you. Not you. It's how it reports. That's the only thing. And that's not something we can change, but it's something we were asked to talk about.
I'm sorry, could you expand on that a little?
Yeah,
Mr.
it's,
Cantrell?
and I don't want to speak too much out of turn here, all right? I've had conversations about the position being directly under you. And now that, it doesn't matter because if the person's going to report to you. The issue, from my understanding, and I want to verify this before we go through anything, but right now, the way I understand it is you're the assistant and you're the HR. And it's not that we're doing something wrong, because I think we're trying to do things that are right. I really believe that. But I'm under the understanding that there is a perception problem, and how do we fix that? And that's.
Where is, I'm
Uh-huh.
sorry,
It's,
by or where from? Because this is
that's
the
where
first,
I've got to verify that.
this
because
is the first time it's been communicated. That really needed to have been communicated
What's, this is,
numerous times and a long time ago, but we can always make any changes. Remember that the city commission approves the budget, which approves the structure of all departments, and our charter does include and lists the departments of which human resources is listed, and it is still a department that
Understood.
reports to the manager, similar to the other departments that are listed in the charter that report to the manager.
I understand, and there's no problem with Megan. I want to make sure that's understood. There's no problem with you.
No, not,
don't-
it's not about the
That's-
positions, it's the structure, but we do need, if there is an issue or a concern, that needs to be communicated, and out of professional courtesy, it does need to be communicated out of the meeting
Yes,
so that then it can be fully discussed by all at a future meeting.
I agree. I agree. That's why I don't want to go, because I don't know enough to say everything I need to say. That's what I'm trying to tell you. I don't know enough. I know that there's a perception. That's what I know. And I've got to talk to the people that have spoken to me to make sure that I'm mentioning it properly.
Okay.
That's, all right. Offer letter, city appeal form, city's appeal form.
I'm assuming that's the complaint form, not the
Complaint
grievance.
form, yeah. Yeah, safety manual, because there's a reference in here about following the safety. There's safety manual. I think that's already established, isn't it? Mr. Gomez, you already have.
We have a safety
You
manual.
do, yes.
And each department also has their safety stuff as well.
Okay. And I don't know who wanted to do this, but the PowerPoint history presentation, Civil Service Commission, how it came about, where we're at.
Did it?
And why we're there. I did
Well, I
a
know
little
during
bit of
that,
it. Yeah.
that time you wanted like old history of how it all got
Yeah.
started, and eventually you wanted to do a PowerPoint. And then you also did a PowerPoint of when there were grievances and
I
things
remember.
like that, so.
It was
if
the
you-
last chair. It was the last chair.
That's right, and
Yeah.
they wanted to know a history of from the beginning, it's
Yeah.
like a synopsis, but we could do that and bring that forward. I mean, I'm good at that.
But you're correct, I've already done
I believe so.
that. So it's, I guess it's about I guess I should show it to everybody, not today or tomorrow, but show it to folks, hey, are you guys okay with this? What revisions you want? Boom, finalize it.
And that could be part of your rules discussion as well.
Yeah.
Okay, all right. So, next meeting is not necessarily December 4th, it's going to be October 24th, October 24th at 4 PM,
Yes,
correct?
October 22nd.
correct.
Second.
Thank
The
you.
22nd.
I totally messed everything up on that. I wrote 24th at 2 PM, he told me 4 PM, so I still had it wrong.
There's too many twos and fours, and they're getting messed up.
All right,
And remember, we're gonna do our officers and the final approval of the employee handbook.
yep. Any questions, any more input?
Joe, is there a date in November that I need to put on my calendar, or no?
November 13th is when this will go to the commission. We don't have to present it. I know that I plan to be there. We can be there if we choose, but it's not
Okay.
a joint meeting. It's not
Okay,
a joint
got it.
meeting.
I just want to make sure stuff gets, so right now, 10/22 at 4 PM is the only thing I need to have.
Yes.
For sure on my.
Yeah, oh, and December
Next one,
4th.
y'all can make
December
some
4th
And
at 4
December
PM
4th.
is the one after that. And then we've already got we've got more meetings than this scheduled already, right?
I believe so.
Yeah, it's better to make the next one. I've noticed that if we make it at the meeting for the next one, it don't get changed all the time, but where we have several, then they all get changed.
Yeah, but the charter does require us to put the quarterly up front, I believe. Is that correct? We do have to schedule them is it okay to do it that way?
That's after
You can
your-
schedule them in December.
Yeah.
Right, that's after your manual is
Okay,
done.
all right, cool. I don't think is there anything else, anything for you, Ms. Van Blargen?
No, I'll put a packet, I'll wait on the final from the attorney, and then I'll put a packet out with that final draft that he has that he would like for you all to look at and
Okay.
bless and everything at the next meeting.
Understood. Ms. Powers?
Well-
Do I have anything?
Mr. Gomez?
We'll have the agenda for the next meeting, hopefully at least a week prior to the October 22nd
Yeah, to
meeting.
give you time to look through it and make
Mr.
your final
Ashenfelder?
comments.
I think I already asked, but anything?
Good.
All right, let's adjourn, guys. 5:36 PM.